Hello, my name is Attorney Paul Chang, and this is another session of Ask the Attorney. I wanted to thank you for being here, but more importantly, I wanted to make sure that you look at our initial video, which says that this here does not create an attorney-client relationship. Today's question comes from Charles in Pomona. He says, "Dear Attorney Chang, my employee has sued my company for personal injury sustained while driving a company car that we provided for her. The person she hit has also sued us as well. She was driving home at night and decided to make some photocopies for the business. This was not requested by our office. When she left the photocopy center, she ran over an old lady. The old lady did not die, but sued us for all of her injuries. I thought in California, businesses are not responsible when an employee is not working. Please help me from pain. I don't know what to do." Charles in Pomona. Well, Charles, in California, there's a general rule, and that is called the going and coming rule. The going and coming rule comes from a jury instruction, KC 3724, and essentially it says, in general, an employee is not acting within the scope of employment while traveling to and from the workplace, but if the employee while commuting is on an errand for the employer, then the employee's conduct is within the scope of his or her employment from the time the employee starts on the errand until he or she returns from the errand, or until he or she completely abandons the errand for personal reasons. What does that mean? Essentially what that means is this: if the going and coming rule applies, generally the employer is not going to be liable. However, there are several exceptions to it, and one of the courts enunciated it. Several exceptions are, apart from what we just discussed, where an employee goes on a business errand for his employer, leaving from his workplace and returning to his workplace. Where an employee is called to work to perform a special task for the employer at an irregular time, and where the employer asks an employee to perform a special errand after the employee leaves work but before going home. So essentially the question that I have for you is this: there are two sides to everything within the law. The person seeking liability from you, the employer, is going to say that she was working on a special errand for the employment relationship, and therefore liability should occur and the old lady should be compensated. The flip side of that is you are going to argue, not at all. We didn't want her to do that. We wanted her to photocopy during work hours and not after hours as she did. So again, the question on this is, what was the primary purpose of her going to photocopy? Was it that she was doing it on her own time, or was it that she was doing it based upon what you asked her to do, and liability will occur whether for or against, depending on the events that we spoke on earlier and the issues and the factors we spoke on earlier. I hope that helps. Take care, and we'll talk to you soon. Take care.